Hi, my name is Kelse Moen, and I'm an attorney in the Antitrust Group at Melvin & Myers, Washington, D.C. office. Together with my colleague John Roberti, who is an attorney at Cohen & Gresser, and Nicholas Powers, an economist at the Brattle Group, we've written an article called Differing Proof Requirements in Global Class Actions. Our article was inspired by decisions by the Canadian Supreme Court in 2019 to change their laws in certain ways that differed from the class action standards under American law. We looked at differing ways to structure class action standards and attempted to arrive at what we call the similarity standard that properly optimize the different considerations in class actions.
Yeah, so we use economic analysis to set up a framework to assess the trade-offs and allow policymakers to use this framework to look at setting their own optimality standards. So we don't derive a single optimal standard. It's really up to the policymakers who are going to have different preferences and different policy goals to assess these trade-offs. And so some of the trade-offs include effects on litigation costs, effects on deadweight loss that competition law seeks to minimize, and takes into account not only the direct effects, but also the effects as key actors in the system, attorneys and other parties, adjust their behavior in response to the changes to the the similarity standard.
While the law in the United States on antitrust class actions is pretty well established, the law in jurisdictions around the world is still developing. So Nick, John, and I believe that this article provides a useful framework that can be used by policymakers in all of these jurisdictions around the world as they work on developing their law and understanding the best way to weigh the pros and cons of different class certification standards.
So on behalf of Kelsey, John, and I, we're delighted and honored to accept the award, and we hope those who view this video will be interested enough to go read the article.
Thank you.